All right, we're going to get started. Hello, good morning, everybody. Good morning. Good morning. Alrighty, so I am Connie Kratovil-Lavelle. I'm the Director of the Department of Family Administration. I think I know pretty much everybody in here, but just in case. And I've been asked to kind of facilitate this discussion this morning. But what we'd first do is introduce our panelists. And we have Nancy Welch. She is the William Trickett Faculty Scholar and Professor of Law at Penn State University, Dickinson School of Law. Her research and writing focus on dispute resolution and procedural law. She's written more than 60 articles and chapters that have appeared in Law Review, Law Reviews, Dispute Resolution, and Lawyers 5th edition. She's examined negotiation, judicial facilitation of settlement sessions, court-connected and agency-connected mediation. This is what I thought, I'd like to hear more about this later. She's also conducted research as a Fulbright Scholar in the Netherlands and was named a visiting scholar at Harvard's program on negotiation and a visiting fellow at Indiana University's Institute for Advanced Studies. She received the Most Valuable Peacemaker Award from the Pennsylvania Council of Mediators, among other things. She received her BA, magna cum laude, from Allegheny College and her JD from Harvard Law School. And you can read the full bio, I think, probably in your materials. Miss Elizabeth Case is our magistrate from Howard County. She graduated with honors from the University of Maryland, this Francis Carey School of Law, which is now a mouthful. We're supposed to say the whole thing. In 1986, after graduating from law school, she served as a law clerk for Marshall Levin at the Circuit Court for Baltimore City for most of her career, about 30 years, as I think you had said. She was a family law practitioner, mediator, and also practiced collaborative law among the kind of the earlier practitioners in the field. She was trained as a mediator in 1997, and I guess you joined the bench, what did you say, about 15 months ago? It's been about a year, not quite a year and a half. So she brings a particular perspective. Not only is she representing the bench perspective, but also a practitioner's perspective. So I think we have a rich panel here this morning. Before we go on, we thought it might be helpful, though, if we could just really briefly go around the room and see where everyone's from. We can maybe tailor some of our comments, and we'd like to know who are magistrates, who are judges, who are practitioners, and others. Janet, how about we start now? Of course, everyone knows who Janet is.
I don't know about that, but Janet Fair. I'm the ADR coordinator with the Juvenile Court in Baltimore City, and I also am a mediator for the Family Court in Baltimore City.
Hi everybody, I'm Lou Giesel. I oversee programs at the Administrative Office of the Courts.
Hi, I'm Alan Weiner. I'm the Court ADR Resources Director with Macro.
Hi, I'm Lisa Simons. I'm the ADR Coordinator in the Circuit Court for Charles County.
Hi, I'm Susie Eckstein. I'm a private practitioner and the current chair of the ADR section of the Maryland State Bar.
Good morning, Faye Matthews with the Administrative Office of the Courts.
Tim Sheridan, Baltimore County.
Court administrator and also practitioner.
She's going to make sure you all fully disclose.
I went to law school with Connie. What stories?
No.
I go Tom Ross. I'm Judge of the Court for Queen Anne's County. I'm chair of the ADR.
I'm Kate Piper. I'm the Permanency Planning Liaison for the Fifth Circuit, which includes Anne Arundel, Howard with Magistrate Case, and Carroll County.
I'm Jim Weiler, retired judge, Court of Special Appeals, now mediator, arbitrator, part-time judge.
Matt Barrett, Court Administrator, Circuit Court in Cecil County.
Keith Ames, judge, Circuit Court for Cecil County.
Sarah Adams, ADR Coordinator, Anne Arundel County.
Jen Bowman, ADR Case Management, Bristol County.
Julie Rubin, Circuit Court for Baltimore City, primarily Jim Weiler's neighbor. I serve on Judge Ross's ADR.
And my name is Alex Wright. I'm on the Court of Special Appeals, full-time judge, part-time mediator with the ADR Court of Special Appeals and also on the subcommittee.
Elizabeth Momini, ADR coordinator for Talbot County. I'm a mediator and an attorney practicing.
Sandy Dalton, got my start in Howard County and am now the clerk of the Circuit Court in Frederick County. And I'm not an official ADR person, but I ADR my 40 employees in the jury office all the time.
Hi, I'm Megan Menning. I'm the civil case administrator for Baltimore County.
Hi, I'm Anna Marie Anderson. I'm the ADR administrator for Baltimore County, also mediator for community mediation.
Rich Abbott, I'm family law administrator for Circuit Court in Baltimore County.
And soon to be deputy?
Yes.
Deputy court administrator, right, in July?
That's right.
I'm Stacy Smith. I'm the Director of Special Projects at Seadrum here, and I also mediate parenting cases with the Anne Arundel Conflict Resolution Center.
Phil Karoom recently retired from the Circuit Court and the ADR Committee from Anne Arundel County, and coming back part-time to the court and beginning to mediate privately.
Okay, so we thought what we do first, there's two studies we're going to be discussing. The bigger one is the child access mediation, and our professor will talk about that first, highlighting some of the more interesting findings, and then our magistrate will talk about perspectives from the bench and what you've seen after clients have gone through mediation, and I'll talk very, very briefly about some of the mediation programs we support.
And also collaborative law.
And then after that, we'll discuss the smaller study that was done on collaborative law, and we'll talk about what's going on in Maryland with regard to collaborative law. Okay, thank you.
So I also should mention that we had decided that after each of our presentations, we'd have a little bit of time for exchange, and I'm looking forward to that. So I also want to say I'm just honored to be here. I think I was one of the participants in the November 15th, 2010 foundational meeting. It's sort of lost in the mists of memory here a little bit, but I'm really honored to be here, and also I am one of your neighbors because I am from Pennsylvania. And I am so impressed and grateful with the state of ADR in Maryland, the model that you've provided for the rest of the country, and the model includes this research. My hope is that someday Pennsylvania will be able to join Maryland in being as active as you all are in terms of ADR. If you have any ideas on that, please feel free to share them with me. This is really important and necessary research that's been done here. And it's really valuable for the rest of the country, not just Maryland. You've heard about that earlier. What I thought I would do as I talked about the child access research was share with you, here's what I was asked to do. I was asked to provide my analysis of the research. I was asked to place the research in the context of other ADR research studies, and to suggest my view of its potential impact. So I will do those three things. But I also thought that I would share along the way with you some of what I found really important to understand about this research. And sometimes that means that I am going to cover some details, because I think sometimes with this sort of research, the devil is in the details. The angels are in the details too. So let me begin, I think, with that, what I found really interesting from this research. First, in the field of mediation, those of you in the room who focus on ADR and mediation, you know that there has been lots of debate about the different models of mediation that exist. And you, of course, are asked often what model of mediation you tend to use. And so one of the initial areas of recognition, I guess, for me from this research was that it appears to me that the self-labeling that we mediators do in general is not accurate. There is an exception. We'll talk about that in just a second. Those mediators who describe themselves as inclusive, that does seem to capture a certain set of strategies. Those small percentage of mediators participating in this study who describe themselves as evaluative, again, there seems to be a cluster of interventions that characterize them. But mediators who describe themselves as facilitative, and that is many mediators, that doesn't show up anywhere here as being recognizable to somebody observing the mediations. So to me, that actually is a really helpful initial observation, that we really should be looking at these clusters of interventions rather than just focusing on labels. Secondly, let me ask this question. How many of you have read this report in detail, word for word, all of the pages? Okay, that's actually helpful to me. That's good. In your materials at tab 2, you will find this report. And I would actually appreciate it if you would go to pages 31 and 32 of the report. Do I sound like a law school professor? I apologize. Beginning at the bottom of page 31 and then extending on to page 32, you actually see the different interventions, the different behaviors that ended up being significantly clustered and then described as fitting into either mediator reflecting, mediator offering perspectives, or what I think is also called mediator telling. I think that's how it's described in some of the other materials. Mediator eliciting participant solutions, and then mediator directing. All right. So I want you to look with me for a second at mediator reflecting and the kinds of things that are included there. What does mediator reflecting mean? It means in general, a mediator is somebody who tends to reflect back what the mediator hears from the parties. So is demonstrating understanding of what the parties has said and has to have allowed them to speak in order to be able to reflect back. So reflecting back emotions, reflecting back interests, reflecting back areas of common ground, reflecting back areas where there's a possibility to narrow or focus. And these are mediators who tended to describe themselves as inclusive. You might have noticed that I did not speak all of the different strategies located here. Here's why. The ones I just mentioned are the strategies that are associated with reflecting. The others, the ones that I did not mention, are the strategies or interventions that are absolutely not associated with the reflective approach to mediation. So, at least according to this, mediators who use the reflecting or fit within this reflecting cluster tend not to provide their own opinion. They tend not to ask fact questions. They tend not to explain. They tend not to make suggestions. They tend not to suggest their own solutions. I think that is useful and interesting. In my world, if you were described as a facilitative mediator, you would be somebody who would tend to use a lot of these reflective strategies, and you would also tend to be somebody who would then ask the parties what solutions they can think of that would help them to resolve their dispute. Notice, though, that mediator eliciting participant solutions is a whole different cluster. And these behaviors did not tend to be associated with mediator reflecting. So what do we see under mediator eliciting participant solutions? Tend to be people who ask for a solution or brainstorm, tend to summarize the solutions suggested by the parties. Absolutely not associated with providing legal information or a legal assessment. Right. I can tell how riveting this is for you. But the reason I'm forcing you to look at this with me is simply because we're going to find ourselves using these titles, and the titles are going to take meaning all by themselves. And I think for all of us, remembering that the devil is in the details and being sure that we go back to this chart and be really clear about what kinds of strategies are and are not included in each of these clusters is important. So let me share with you one last thing here. Notice mediator offering perspectives, which is mediator telling, mediator sharing what legal information would be relevant here, providing potentially a legal assessment. That shows up as something that happens. There's mediator opinion, there's legal assessment, but something that does not happen according to the factor analysis is that if a mediator is somebody who tells, the mediator tends not to reflect back. That's really significant, and I will say more about that in a few minutes. Finally, mediator directing. In my world, I would describe an evaluative mediator as somebody who both does the kind of legal information, provision of legal information and assessment that's currently clustered under mediator offering perspectives, and also is somebody who does mediator directing. But the factor analysis separates these out. All of that, I think, is significant for our field. All right. And then the other thing that, of course, is really important from this research is identifying the effects of particular clusters of behaviors. Laura shared these with you, the highlights with you earlier today. For purposes, though, of my discussion, I just want to highlight these. There are so many good effects of reflecting. So many good both short-term and long-term effects of reflecting. With the participants indicating that they're more likely to perceive that the other participant listened and experienced increased understanding of what they had to say, reducing the chance that they're going to dismiss the other participant's perspective, becoming more likely to believe that they can work together, solve a range of problems, etc. All the kinds of things that are going to be really important for these two parents of children as their family evolves. But again, as Laura mentioned, it's really significant to me that these strategies, these interventions are associated with a reduced likelihood of reaching agreement. That was really counterintuitive to me, but I think is really important. The suggestion that mediator eliciting participant solutions, that it ought to be combined with mediator reflecting, I think is really important for all of us in terms of the mediation models and training and even observations that we're doing of mediators. Also significant to me is that the mediator telling or mediator offering perspectives, as it's described on pages 31 and 32, that those are not associated with any short-term or long-term effects. This is inconsistent with other research, which I'm going to share with you. So it suggests to me that that's a mystery at the very least, and I hope to be able to dig into this a little bit more to find out why. Finally, mediator directing. Really interesting that the short-term effect of the mediator directing is to reduce the perception that the mediator respected them, reduce the perception that the mediator did not take sides, and make it more likely that the participants would file adversarial motions and more of them. One of the big debates in our field has been facilitative versus evaluative. This research blows apart the definitions of facilitative versus evaluative, but this research I think is really significant in suggesting that certain evaluative interventions have very worrisome effects, and again, counterintuitive for many of us. All right, so now, caucus. I have done some research on caucus. I think that the results of this study and the results of the day of trial research regarding caucus are really important for our field. I'll say a little bit more about how it fits and doesn't fit with other research in just a second. So how about if I now place this research in the context of other ADR research studies? There's research that's being done by Donna Shostowski, finding out more about litigants' preferences as they go to court, what sorts of processes they think that they would prefer to be involved in, and then after their cases come to disposition, finding out what processes they were involved in and what their perceptions of those processes were. What Donna has published thus far is regarding ex ante preferences, which are the preferences going into court. I don't believe that the cases that Donna is reporting on tend to be family law cases. I think they are more likely to be non-family civil cases. But what she's reported thus far are that litigants who are going to the court indicate that they prefer the following three processes. They would prefer to be involved in negotiation with their lawyers, so negotiation by their lawyers, but present, with the clients present. Those in the room who are lawyers, how often have you actually had your clients at the table with you when you've negotiated with the other side? I would bet not that often. Oh, very interesting. Well, so that's part of our questions. Second, prefer mediation. Third, prefer bench trial. Which processes do they indicate the least preference for? Non-binding arbitration and binding arbitration. Jury trial doesn't score very high either. So that's one set of research that Donna has produced. Why would people prefer to be present for the negotiations that their lawyers are conducting? Because they want to know that they had voice. They want to be present. Doesn't necessarily mean that they had to speak, but they want to know that their point of view was heard. More recently, Donna has published research that suggests that, and this, we need to look at this more carefully, that suggests that people, despite what I just said, people also indicate a preference for a third party to have control over the process. And that you notice how that can be true for mediation. Mediator controls the process, bench trial, judge controls the process. Negotiation with their lawyers, maybe they could feel that their lawyers are in some sense controlling the process. But her research also suggests that people have some desire for control over the outcome by a third party. That is entirely inconsistent, I think, with the results of Marilyn's research. So right now, all I can tell you is this is an area of mystery, and where there may be significance in the fact that this research involves non-represented parties who are ordered into mediation, whereas I think that most of the litigants that Donna is looking at are represented and anticipate being represented. So it might just be a very different population. There is also research that's been conducted by the AFCC, the Association of Family and Conciliation Courts, that is suggesting in the family area more interest in processes where there are decision makers, rather than relying entirely on a mediation model, and research by James Wall that is also suggesting that people appreciate an assertive mediator. I guess all I can say from this is that there's a need to try and figure out how Maryland's results fit with these other research results. Regarding caucus, I mentioned that long ago I did some research, qualitative research study involving special education mediation. I think there are some areas of similarity between these family cases and the special education mediation cases. People tended not to be represented. In fact, in Pennsylvania's special education mediation program, they weren't allowed to bring lawyers to mediation. And obviously there was a desire for a long-term relationship that was positive between the family and the schools. In that research, I didn't ask any questions about caucus, but I asked the parents and the school officials, both before mediation, what was important to them, and then after mediation, what had been important to them. And they, almost all of them, talked about caucus. And I hadn't asked any questions specifically about caucus. So it was amazing to me how significant caucus was. Sometimes they were describing caucus in very appreciative terms. They viewed it as a time during which they could tell their story. They would be heard by the mediator, much of the kind of thing that you heard today. And then there were other times that they raised serious concerns regarding caucus and the inability to connect with the other party and hear what the other party had to say, when they knew that they were going to be dealing with each other in the coming years. I think that is really consistent with the research from this study, and because caucus is such a significant part of the mediation world these days, I think this research is extremely important. Years ago, people worried that caucus was disappearing. There are increased calls that caucus is disappearing. Now I want to again say, It's important that this is research conducted in the context of non-represented parties where long-term relationships are significant. Maybe the lessons regarding caucus are not as strong in other contexts. So that leads me to my view of the potential impact of this research. This research is really important. Is it relevant outside the family area? I think it could be, especially if we're talking about other substantive areas that involve long-term relationships, or the desire, at least the community desire, for there to be long-term productive relationships. And I'm saying it in terms of the community desire because I have to believe that there are some divorcing parents who would prefer not to have a relationship. But as a society, we know and believe that it's better for the kids if they do. So how could this research be relevant in other substantive areas? Special education I've mentioned. Where there are disputes between professionals and clients, whether it's legal malpractice or medical malpractice. In the elder law area, where there are trustees. Neighborhood disputes, government and citizens. Again, we hope for long-term relationships. I can imagine this research being relevant in all those areas. Potentially less relationship where there are not continuing relationships, personal injury matters, contracts between businesses, intellectual property disputes. Will this research be relevant in settings that don't include lawyers? I think we need to figure that out. This particular research may be most important where people are not represented. And then finally, is this research potentially relevant to other types of professionals? And I think the answer to that could be yes. The power of the reflecting strategy, set of strategies, lawyers who are counseling clients are increasingly hearing that it is important to allow the clients to speak, listen to them, reflect back what they hear from the clients, demonstrate understanding of what the clients have said, demonstrate understanding of their goals. That this is really powerful. And then the client counseling literature is suggesting if you do all that, your client is more likely to listen to you, especially if you're delivering bad news that the client doesn't really want to hear. I think that there's also the potential for this research to be relevant to judges who are facilitating settlement, to managers in the workplace who are facilitating discussions between employees. So I think that this research, we need to be careful in figuring out how it relates to other areas, but I think it has the potential absolutely to relate to other areas. So I think it's really important, and I again want to applaud all of those who were involved in putting this together and those who believed in the importance of it in order to make it happen.
About any questions? Maybe while you all are thinking that, you know what I wondered? With some who aren't trained as mediators, would it be helpful maybe if you gave an example what that means, reflecting back?
Oh, sure, absolutely. So Connie, let me just ask you the question that you asked me. What you would like is for me to be able to demonstrate to everybody the kind of thing that I'm talking about.
Yes.
That's what I just did. Hang on 1 second. And is that important to you because you want to be sure that we're really communicating clearly with people in the room?
Yes.
So you'd really like me to reflect back?
I would.
All right. So actually, one of the things, the devil's in the details. Those of you who really want to get into the details of this research, I would really recommend Appendix E to you as well, which Appendix E is the coding instructions. So when people were sitting in the room and they were observing and they had to figure out how to code what I just did, whether it represented reflecting, whether it represented a solution suggested by a party or it was a mediator proposed solution, those are really nuanced determinations, and that's the kind of thing that is in here. Again, the devil's in the details. These strategies represent the culmination of those observations. So, somebody had raised their hand.
I'm sorry. Not necessarily, I haven't read the report, but in listening to this, many of us have had Myers-Briggs training, which is very effective for not who we are as much as who is the person that we're speaking with. And I don't know, Connie, you may tell us, and do we do a little questionnaire to these clients prior that ask questions about what their preferences are? Are you a direct responder? Are you a feeling responder? How do you like information given to you? So that the mediator has a clue going in that this is my huggy, kissy, feely, touchy, and this is my, I want it straight and to the point, and so that they have an idea of which type of process they should start with.
So really interesting question, and to tell you the truth, it makes me think of, again, go back to Donna Shostowski's research, where she asked litigants questions about elements of processes. She would not have gone necessarily, I'm not sure that it's going to be of value to go into that degree of detail, but I think it will be really important to find out questions like, how important is it to you to be in the same room with each other? How important is it to you to be sure that you get a chance to talk about what is important to you? Are you looking for solutions or assessments from the mediator or the third party? I think those kinds of things, those are the kinds of questions that are included in Donna's study, and I'd be happy to provide you with a cite to her study because I think she includes there the kinds of questions that she asked of the litigants.
Thank you.
May I, in Donna Shostowski's research, I'm wondering about the methodology. Was she asking litigants about their preferences after having participated in certain processes?
Great question.
Yeah, because I'm wondering if people think that they prefer something, but these outcomes are different than what they think they may have preferred.
Right.
And so it might not be inconsistent.
Right, absolutely right. You're absolutely right. And she is doing, she has done both questions before before the litigants participate in the process, and she's now gathered all the data, but has not completed analyzing the data from the questions that were asked after they completed the processes. And I will relate that to the special education mediation small qualitative study that I did as well. We asked people before the mediation, what is it you're hoping the mediator will do? What is it that would be most helpful to you? And the answers that we received were really provocative, I must say, because sometimes what they wanted was that the mediator would the parents especially, would translate for them what was important to be conveyed to the school officials. But what they valued after the mediation session, and then again 18 months later, sometimes varied quite dramatically from what they thought they would value going in. What Donna has suggested, though, is that other research suggests that if people strongly feel that they want something and it's not what they get going into the process, that they may have some resistance to what they receive.
Which talks about explaining the process up front so people know what they're going in.
Potentially both explaining, but also asking questions. I mean, sort of using some of the same reflecting techniques we were just talking about.
Okay.
Yeah.
Could you talk just a little bit more about, you talked about some of the adverse effects that research is showing with the evaluative process. Maybe explain a little more what that is, what it might look like, and why that might not be a good strategy?
Well, so here's the evaluative process in the past, at least before this research. In the past, the evaluative strategy would have included mediators providing their sense of the strengths and weaknesses of parties' cases, asking the parties regarding the strengths and weaknesses of their cases, suggesting solutions, recommending solutions. And as I say this, do you see, I mean, those of you who are mediators in the room will automatically see that this is, there's increasing intensity to what I'm describing. If you're asking questions about strengths and weaknesses, that's still asking questions. If you are then opining regarding strengths and weaknesses, that's a move up the evaluative scale. If you're actually proposing solutions, that's another move up. And if you're recommending solutions, that's another move up. What the research had shown in the past is that, but again, research emerging out primarily of non-family civil matters that included lawyers. That litigants actually appreciated, they were more likely to perceive the outcome as fair if there had been some sort of an assessment. And my hypothesis regarding that is that it reassured them that what they were coming to was within the range of fairness. On the other hand, if the mediator went so far as to propose or recommend solutions, people there was a great danger that people would not perceive the process as fair. And that was especially true if the case had not settled, right? I mean, they had rejected what the mediator proposed. But then the mediator essentially became another negotiator in the room for the adoption of his or her proposed solution. All right. What I think is really interesting with this research is that there's no effect that's shown if the mediator is telling, if the mediator is offering perspectives, and that includes the mediator providing information and the mediator doing some assessing. Where the negative effects show up from this research are if the mediator directs, the mediator tells people what to do, but also this includes the mediator explaining the other side's point of view and the mediator also advocating for somebody. If the mediator, again, I go back to this cluster of particular interventions. It's really important to keep going back to the specifics of the cluster. If the mediator engages in this cluster, then people are less likely to perceive that the mediator respected them, and they are more likely to perceive that the mediator took sides. And it is more likely that they will file adversarial motions, and they will file more of them.
Or administrative people per day.
Because that is going to not reduce your docket, it's going to increase the docket. But I keep coming back to, it's really important to identify which particular strategies are associated with the mediator directing cluster and which are not. And I guess this whole thing that I just said suggests to me that it could be really valuable to see if there are particular strategies that can be teased out and identified as having the greatest effect in causing these negative effects. That could be really helpful.
Can you explain coding-wise the difference between the telling, an example being offering solutions or assessing legal options, and the directing? Like what makes it a tell as opposed to a direct?
So let's look. So again, I'm going to go back to pages 31 and 32. And I am also going to invite people in the room who were directly involved in observing to feel free to correct me if you think that I should be corrected. So I look at these strategies, this set of strategies, and here's something I see in both places. Mediator opinion shows up under both mediator offering perspectives and also under mediator directing. So it's the same thing. That's the same thing. But some of the kinds of things, and so under mediator telling, introducing a topic, a mediator suggesting a solution, providing legal information, all of these, no effect. But when you got the combination of mediator opinion, mediator is actually advocating for a particular position or a particular party, supporting the argument made, I think, in general, by the other side. The mediator is telling people what to do in terms of behavior in the mediation. All of these, what I really wonder is whether some of these particular strategies are the ones that are then resulting in the negative effects of the mediator directing cluster. You and I, in order to figure out exactly what shows up under mediator directing versus mediator offering, would need to go back to Appendix E and differentiate. So mediator opinion shows up in both places, but advocate support does not, behavioral direction does not, explain does not. Explain only shows up under mediator. These three only show up under mediator directing. So my current hypothesis would be it's those three strategies that are more likely to result in the negative effects we see for mediator directing. That's just a hypothesis. Does that make sense?
All right. Thank you. And shall we, magistrate case?
All right, so like Professor Welsh, I want to say how sort of more than honored, I'm a little taken aback by all of her credentials and to be on the same panel. I mean, basically, I'm a family law attorney who became a magistrate a little over a year ago. So I have never been good at research or understanding that kind of thing, but I do clearly get what this research means for us, and us as an ADR community, us as a judiciary. It's very significant research. And the two things that struck me the most is that what these results show is we're on the right track. I mean, we thought we were, but now we have actual data supporting that we are. And that being the fact, and all of the positive results of the use of ADR, and I include collaborative along with mediation in there. There have been some movements involving collaborative in the court system that are promising, that this needs to be expanded. It clearly needs to be expanded within the judiciary. And the other thing that is striking is it's all about the process. Not only is the result, meaning you got a settlement, an important thing, it's about the process and the long-term impact of the process if the process is done right. Meaning, not only are you eliminating dockets at the beginning because you've settled a case and now it's taken off your docket, but if it's done the right way, this research is showing that the results are long-term positive in terms of reducing dockets down the road, because the people are not going to come back. So it means both that we have to expand the use of ADR and that we have to make sure that the ADR practitioners, and I would submit the judges who are doing settlement conferences in the courts, are trained in effective strategies for getting the results we want. And that the basis of those trainings is really going to be these clusters that Professor Welsh was talking about, because we want the parents coming out respecting each other. We want the parents coming out being able to talk to each other. We want the parents to think, oh, we have a difficulty, how do we resolve this? Not, how quick can I file something? And if we have mediation that's not effective or produces some of these negative results, then in the end, we've done a disservice, one, to the children, who are going to have this continuing conflict, two, to the parents, who are going to have to deal with this continuing conflict, three, to the perception of the judiciary, and four, to the function of the judiciary in terms of it being efficient financially and in meeting time standards, which is a big deal now. And so that was my first topic, was what were the most significant things that I learned. Then I was supposed to talk about the judiciary's perception of ADR, and I think that's widely variable. In general, I think it's positive. I don't know that all judges fully appreciate what ADR is, what the different forms are, that there is a difference between sitting down with two people and saying, so what was your offer? And so what's your demand? And well, in the middle, it's 50,000. I mean, that's ADR, right? Okay. What the study shows, and what most mediators and ADR professionals know, is that that is not the process that is going to get you the best result. And while you might have a settlement achieved as a result of that, it will not necessarily be a lasting solution. And when it's done right, whether it's collaborative law or mediation or a settlement conference, and there's an agreement reached that the parties fully participated in, that they didn't feel they were bullied into, they're going to have a lasting result. But the effect is wider than that. And that is because if the process is done correctly, the parents will have a different perception of each other and the value of what that other parent has to say. When you do mediation or collaborative law and the attorneys or the mediator are soliciting the feelings and the suggestions of each parent, it models for the other parent, this person has value, this person is just as much a parent as I am, this person has things worth saying, this person is somebody who should be treated respectfully. And that modeling is something that has a long-term effect. You can't overestimate the importance of that. And that's why you see the positive results even when they don't reach an agreement. You see the positive results. They're more satisfied with the process. They feel like they were heard. They feel like they now understand the other party's position. They feel that they would be able to talk with the other parent about a problem, even if they didn't reach agreement on the topic that was the subject of the mediation. That is absolutely huge in so many dimensions. several levels of value, and that is to the family, to the perception of the judiciary, and the efficiency. And I think tomorrow we're going to be talking about how do you take the study and use it in your individual ADR programs. And one way is that they need to be expanding, and the other way is that training component. I found it fascinating, the caucusing. I always felt that way as a mediator and doing settlement conferences at the courthouse. I am always reluctant, even a lot of times I'll have attorneys say, really don't get along. I think how about if we're here and you're there, and you could do that shuttle diplomacy, couldn't you? And I'm very resistant to that because I've found just through years of experience that you don't make the same kind of progress because what you're doing is avoiding the conflict rather than working through it. You're going to one side and letting them express it, going to the other side, letting them express their side of it, and then maybe you're proposing a solution or a settlement. How about if it was 128 overnights? Yeah, I guess we'll take 128 even though we wanted 156. Done, we have an agreement. But did those parents ever get a chance to work through their difference of opinion, take a look at their child or children and what their specific needs are and who can best address those specific needs and come up with a plan that makes sense? Or did they just do the equivalent of a negotiation for a motor tort? I want 50-50 custody. I want sole custody. How about if it's 128? How did that help the parents be able to resolve conflicts as they arise in the future? They don't have a mechanism for doing it. They don't have the knowledge of how to interact with each other respectfully. They don't have any basic empathy or understanding of where the other person is coming from. And because of that, it only makes sense that as the study shows, these parents are going to come back and file things because they got a solution. It was 128 days. But they never worked through the conflict that I've been a stay-at-home mom all this time and you didn't come home till 8 o'clock at night and now you think you want 50-50. They never found a way to talk about it and to get past it. So it's going to still be there. It's all about the process and doing it right. So that's pretty much all I had to say on the topics that were assigned to me. It's huge, it's valuable, and it has practical applications.
Does anyone have any questions?
So, thank you for that summary. I find myself thinking, I guess the question is to get your thoughts on how and when and the appropriateness of encouraging couples to use mediation maybe more than one time in a particular family case. As I'm hearing you say this, I'm thinking about so many times where I've talked to somebody who's going through a custody battle or a divorce, and if they don't come to an agreement in mediation, they don't blame the mediator, they blame the other person. They say it was because this other person wasn't reasonable. But what I find more often is they do come to some kind of agreement. They think that the mediator is wonderful, but then 6 months later, the first time a person violates the agreement, they're dragging each other back in court, and they think, well, since the agreement didn't hold up, then mediation is all over. And I've seen people just continue to go record until their children turn 18. And so I was just wondering what your thoughts were on that, given everything you just said and what the research is showing here.
I have a lot of thoughts on that. I used to present at the parenting seminars for the National Family Resiliency Center, and I called my presentation, "Why to Negotiate, Not Litigate, Your Family Law Matter." And one thing I would say to them is, how do you mediate? When do you mediate? Early and often and every way that you can. Every way that you can. They should be given multiple opportunities to have that kind of resolution and encouraged to fully take advantage of it. Also, in agreements, in my opinion, agreements should all say, if we have a conflict about little Johnny, we will return to at least two-hour sessions of mediation before filing anything with the court. That's an easy way to give people a chance before there's even any filing. It's also helpful to have wording in an agreement that contemplates that when Johnny turns 4, we're going to talk, and if we can't resolve it, we're going to go to mediation to talk about, will the schedule change when he goes to kindergarten? Will we have a mechanism for choosing what school should he go to? So agreements should give parents the mindset that what you do when something changes is first you try to talk about it before you file anything, and that it's normal for things to change over time. That doesn't mean somebody's necessarily messing with the agreement or in violation of the agreement, but the child's needs may change. So you normalize the expectation that there will be change.
Do you mind if, can I just? Sure. Such a great question. And again, I think that requires going back and looking at the strategies that were used by the mediator in the mediation session, because it's really striking that the mediator's using the reflecting strategy. In the long term, the parents are more likely to report that they can talk about their concerns with the other parent, that they can work as a team in raising their child, that they prioritize their child's needs, that they are willing to consider the other parent's perspective. And it just makes me wonder whether the example you've given would have been less likely to have occurred if it was a mediation in which the mediator used these reflecting strategies, combined, of course, with eliciting solutions in order to get an agreement. But it's so important for us to get beneath the term mediation and find out exactly what's occurring.
It should have.
Yeah, I was just going to say, one of the other things we do in Baltimore County is we institute a program where all contempt mediation, any contempts that are filed in custody visitation are referred back to mediation as well.
That's great.
So we have quite a bit of success with that as well. Now, again, less likely to probably settle and resolve the case at that point in time, but we still resolve quite a few.
Yeah, that's great.
Digging back, Lou, I think you said earlier, like, where do you go? Did all this great research, talked about it, and where do you go next? And I think what I'm hearing is kind of like quality control. And it used to be 10 years ago, do you have an ADR program? Do you have this? Do you have the settlement conference? Do you have mediation? Do you have this? And do you do pre-trials and reports and things like that? And I think that's pretty pervasive, at least in most parts of Maryland, a lot of program managers here. But there's also a lot, I won't call it bad mediation going on, but maybe ineffective mediation. And then at, no offense to judges, at the judge at the settlement conference, training at that level, it's not mediation, but it's still family cases. Are they being evaluated? Or is that process effective? Could we be more effective at that process? And then this program managers too, there's probably a lot of people that really think they're good mediators that maybe aren't, or aren't effective, not bad mediators, and that there are quality, there's some rules or ethics or specifics on those issues. I don't know how much it's enforced, or how much is just said, well, he's been here for a while, so why don't you take this case?
Yeah, and I think there are some courts where they have a list and they actually just go down the list in order of the mediator roster, and that's fine. if you make sure that everybody on the list has had what your program determines, or the state ADR determines is appropriate training, using, even for people who've been mediators for a long time. This is new research, so that theoretically, everybody that you're using should know about this, have an understanding of it, how to do the things that are helpful and not do the things that aren't helpful. You probably get better results, frankly, in the courts where they know, the practitioners, and people come for the scheduling conference, and the lawyers know everybody, and they're like, can we have Miss W? Yes, you can. Or, we don't know we're from out of county. Who does the court send people to? Miss W, would you like to go to Miss W? Yes. And you get good results because you know that person gets good results.
But you hit some ethical, I mean, is the court steering business if you're getting paid, and as opposed to pulling off the roster? I know some of the people that you're sending this case because so-and-so called the judge and they say, I'm not getting my share of cases and I'm not getting my money. And the answer is, well, you're not getting your share of cases because she's not really good. But she's not going to, you don't tell them that.
That sounds like time standards. Measure what they do.
That's Richard's job.
But you also have, the court can't really steer business.
Right, which is why I think what you have to do is have it be the requirements to be on the list. And then presumptively anybody that goes, anybody they go to knows the effective strategies.
And taking quality control to the level inside the court too, whereas we know in courts that there are some judges that are excellent, magistrates that are excellent at settling cases and people leave happy. I'm sure that's the case too, and some that it's not the best experience. But is there any, we don't really rate that, we don't measure that.
No, but we know it, and we sometimes steer things in an appropriate fashion. But isn't the answer to that, again, training?
Well, it just, how many judges and magistrates just went to the courses that were offered? That was a great idea.
Yep, great idea.
But being on the list doesn't make good cases. Good cases, we would never go from top to bottom like I know some counties do. Because there are other considerations also. I mean, there's geography as to where the lawyers and parties are, if they're going to other offices, things like that. So we look at a lot of things. I think you can do that. On the other issue, you brought up settlement conferences or training for judges. Just add that discussion with another judge, and I do agree with that. A lot of judges out there who only do settlement conferences who probably haven't been to a training on mechanics of settlement conferences. I'd like to see this go. I'm definitely pushing that.
And this study, based on the ability of the observers to code, Maryland is known for its contributions to best practices. And it just seems to me there probably could be some product from this study that would enable some program within a court to provide for observers.
Very good.
Using what are best practices.
That's another thing that we just did, thanks to Macro. We had a coaching pilot program where we actually had 20 mediators who went through their own 2-hour mediation where the parties agreed to be observed and had 2 very highly trained trainers of mediators who observed, and then the requirement for the mediator was to stay for 2 hours and discuss what went on in mediation.
That's great.
None of that came back to the court. It wasn't for punishment. They got credit for their 4 hours of training. It was wildly successful. I had lots of people approach me and say, why are we doing this, and what's your involvement in it, and that kind of thing. But the people who did it, I heard from 3 or 4 of them said this was wonderful, and I saw all those comments that came back saying they were glad they did it.
Yeah.
Yes. In in our county, we also don't go down the list. We make sure that all our mediators are up to date with their continuing education. We look at their background. And recently, I actually, to my surprise, under Title 17, if a mediator, so you have your mediator qualifications in order to be on a county court roster. However, there's another part of the rule, Title 17-206, that discusses any other ADR professionals, such as settlement court judges, etc. And they have certain other criteria that they also have to follow, but it doesn't say anything under continuing education, that they have to require continuing education. So one of the problems that I recently had is I had a roster mediator who had not been following continuing education. He says he's had 30 years experience as a mediator and has had other experience as well, that he doesn't need to be part of that roster, that he'll be a part of this other roster that currently does not exist in Baltimore County. So it is a problem as far as quality control, in the sense when there's loopholes in the rule. The fact that we require 4 credits of continuing ed every year, but some people go 3-4 years without taking continuing ed and then take 2 days of continuing ADR education to make up for the 2 years and say, I'm active again. So those are kind of situations that we're coming across. But I think for quality control, one of my hardest challenges has been when we're trying to keep a close roster, trying to keep these mediators up to date and have the best mediators that we can have for our cases. But then we have parties that choose a private mediator, which they can, and of course I'm happy they're going to mediation regardless. But with the private mediators, that quality control is missing. I can't have any control on whether or not they've been doing their minimum qualifications, because technically it's recommended they have it, but they're not on my court roster. So that's where the biggest problem's going as far as quality control. And I don't know if you have any suggestions regarding private mediators not on the court roster and under my quality control.
My personal experience has been that most of the people who are doing private mediation, they're only getting the business because they're getting the results, and they're being chosen by attorneys who know their clients and know that mediator. So that wouldn't be a huge concern of mine, as much as having people on a list that you're sending somebody to that may not have the skills that you want them to. I think there's built-in marketplace quality control for private mediation, because people just aren't going to go to you if you don't do it and do it in a way that's effective. Now, it may not be that you're using the right skills so those people don't come back 10 years from now, I don't know. I think it is going to be true that they're likely to get you to your case being resolved, or the attorneys aren't going to choose to utilize that professional.
So we've got a couple minutes left. We're going to do and if people have further questions, we can stay afterwards. We just want to hit a couple of things with collaborative law, if that's okay, in the next 3 minutes. So. You should have in your materials a study that was done, I think it was published December 2013, on the use of collaborative law. It was, as far as we know, the first judiciary kind of commissioned study on the use of collaborative law in the country. And Maryland, what I thought I'd talk about very briefly, is the state of collaborative law in Maryland now. And the Maryland Judiciary has done more, Susie, would you think, than probably any other judiciary in the country, to promote and expand and explore the benefits, the costs and the benefits of collaborative law. Real quickly, does anyone not know what collaborative law is? No, that might isolate people, so I'm going to do this instead. Quickie, collaborative law is a process. This is the purest, don't get mad. We only have a minute. It's not Susie. No. Collaborative law is an ADR process wherein both parties have attorneys, and the attorneys and the clients all get together. They agree they're going to do everything they can to reach an agreement out of court. They're going to put all their information on the table instead of tortured discovery process, and they're going to work together in the family law context and the custody context to reach an agreement that's best for the family. Okay, so that's, and then if they don't reach agreement, the attorneys don't go to court with the clients, and it's a way to incentivize people. So with that being said, we have in Maryland, here's what's going on. Maryland has had the first judiciary-sponsored training of attorneys in the country. That was 2012. We've done 5, I think, since then. At the time, there was about 100, and this is reflected in the study, there were about 188 collaboratively trained attorneys. In the state, we've now more than doubled that with these trainings. These trainings require the attorneys and other practitioners. By the way, there can be a team approach. You don't have to have the team approach. You can do the Ford Focus model versus the Lamborghini model. Purists don't like that, but it's true. And then you can get results. But when the team model is when you have not just attorneys, you have mental health people, because those of us who have practiced family law know that everybody's crazy when they have a domestic case, right? And they could benefit from having counselors. So you have some of these other professionals to help work through some of the other pieces. And those of us who have practiced this say, hey, you, instead of paying me X amount of dollars an hour, it'd probably be more helpful if
talk to Dr.
somebody who's better equipped to address that. So we've had about 5 trainings. The deal is with the trainings that those who attend have to agree to take at least 2 collaborative law cases pro bono, which fits in nicely because Maryland also helped establish and fund and support the first pro bono collaborative law program in the country. And Susie is here. Susie was the president of what's now the Collaborative Project of Maryland, first of its kind in the country, where low-income people, a lot of folks say, collaborative law, that's so expensive. You have attorneys, life coaches, who can afford that? We say, hey, if you don't have money, we have a place you can go to if you don't have enough money where you can have this process. So Susie's organization's Collaborative Project of Maryland covers cases statewide. We also have, near and dear to my heart, the Midshore Pro Bono organization on the Eastern Shore. Also at the same time, we were sort of surprised because when we put out our NOFA, if you all know what a NOFA is, it was tailored with figuring you all were going to take advantage of it, but our industrious Sandy Brown at Midshore Pro Bono also applied. So we have coverage for low-income people who can't afford attorneys, can't afford other professionals to help them resolve this dispute. We now have 2 organizations in the state that help folks reach agreement. Our grant reports are showing that they're reaching agreement in over 95% of those cases. And with our group with the pro bono portion of the program, and hopefully we'll have a published study on this, we need a little more time and data. The pro bono folks have reached those agreements in like 3 months, not 18 months, not 24 months. It's magnificent. So let me hit a couple of the highlights and then
Although part of that may be the fact that they don't have to deal with complicated and extensive financial issues.
That's exactly right. So they're not worrying about valuing the family business or the home in Aspen, but they are managing debt. They have some complication with the managing debt issue. So here's what the study, I'll hit a couple of the highlights in the study, and then if anyone wants to ask questions. In general, sort of nationwide, what the research is showing is that in these collaborative cases, attorneys are spending about 30 hours. That's not a lot. It's not a lot of hours. The average is 6.3 months to reach an agreement from the time they're referred to finishing the process. In Maryland, the cost for clients, now this isn't our pro bono project, this is paying clients, regular old paying clients. The average cost per client's been $8,900. That's a lot better that's a lot better than the litigation process, that 87.4% of the cases are reaching agreement. And in our smaller, kind of informal, less scientific study, it's more like 96%, and between 96 and 98%. Won't get into all the details. And the study is showing that people are either the parents in these cases, these custody divorce cases, are either in 75 to 78% of the time are either extremely satisfied with the process or satisfied with the process. Judge Karoum.
Your 8,900 average cost, is that per participant or per case?
For each of the mom 89, dad 89. Yep. Good question. And I think those are big highlights, and I think importantly it's also showing that this is less costly. It's quicker than, I know, with the purist. It's often is, at least our study is showing, it's quicker than litigation for sure, and it's less costly, and just like mediators talk about, the parents and perhaps some of the professors, some of the information where people also, because they have attorneys, they're getting some of that feedback, assessment, here's what would happen. The parents are able to talk to each other, and they're not the frequent flyers filing emergency petitions, every 30 days. Okay, so that was the skinny. Yes, ma'am.
I'm going to interrupt, and if you want to stay and continue a rich discussion, I don't want you to forget about the feedback form that Jonathan mentioned. This is in here, it's this yellow one. You want to take it with you, fill it out. You can leave it at the registration table, hand it to me, whatever, throughout the day. Our lunch has started, and our lunch panel will probably start at 12:20, so I don't want you to miss any of that. We have other breaks and a social hour after the program today.
Okay. Does anyone have any questions you want to, or if anyone does, you can stay. Come on. How about that? Yeah. All right. Thank you. Thank you.
We're coming back to this room for the next.
Okay, you were very good.
I'm sure. Yep, that's right. It was and they have suggested a couple of times, and I'm going to including to our ADR.